Hello and welcome everyone to the CADR panel discussion on the interface of arbitration and mediation vis-a-vis the Singapore Convention. I am Mahajan, convener at CADR, and on behalf of Dr. Gurpreet Kaur, faculty coordinator CADR, and Samiksha Sharma, convener alongside me, we thank you for joining in. CADR-RGNUL is a center for research and excellence, and since our initiation, we have made dogged efforts to build capacity and build a community of international practitioners, academicians, and students. At CADR, we have followed the Singapore Convention as it heralds to be a game changer for mediation practice in India and globally. And to celebrate the enforcement of this convention, we are ecstatic to bring to all of you this brilliant panel of practitioners and leaders, and we look forward to the discussion. Now, I won't, I see we're already short for time, so I will briefly introduce Bhavya, but she might be too modest about her own introduction. So, Bhavya is a case manager at the Mumbai Center for International Arbitration, MCIA. She has worked extensively in mediation, including at the Office of Ombudsman for the UN Funds and Programs in New York as a graduate intern. Bhavya holds an LLM in dispute resolution from Pepperdine University, and she's a member of the UN Multilateral Working Group, as well as the working group of Child and Youth APR at Mediators Beyond Borders International. And she has several mediation-centric publications to her name. With that, we look forward to this exciting discussion, and I will hand the floor over to Bhavya for introduction of the panel and to begin the session. Bhavya, the virtual floor is all yours.
Thank you, Mohit, and a very warm thanks to the CATR for organizing this event. And welcome to all our panelists and attendees. Thank you for joining us today. It is a privilege for me to be moderating this panel discussion amongst such esteemed panelists. They clearly do not need any introduction, but it is customary for me to do so. Starting off, we have Justice Kannan Krishnamurthy with us. He's a practicing senior advocate and a mediator. He's also a former judge of the Punjab and Haryana High Court and has served as the chairman of the Railways KM Tribunal in the past. Justice Kannan has published extensively on different areas of law. He was also a recipient of the Weinstein Jams International Fellowship and received his mediation training in San Francisco. He's the founder, director at Madhyastham, which is a conflict resolution portal that promotes mediation as an effective conflict resolution tool. Justice Kannan is also a sitting member on the panel for Indian Supreme Court mandated draft mediation bill. We welcome you, sir. Mr. Francis Go is a partner at Harry Elias LLP in Singapore, where he is the head of the international arbitration practice of the firm and head of the private client advisory. Francis has more than 25 years of experience in dispute resolution, including international arbitration and mediation. Francis is an accredited mediator since 2001, a principal mediator with the Singapore Mediation Center, and was recently appointed as a specialist mediator and ambassador at the Singapore International Mediation Center. He's also a fellow at the Singapore Institute of Arbitrators and serves on their council. We welcome you, Francis. Moving on, we have Mr. Paul Eric Mason with us. He is a US-based lawyer in Miami and Rio de Janeiro, Brazil. He serves as a counsel in commercial disputes and is also an arbitrator and mediator for various ADR institutions worldwide. Paul was the first mediator in Brazil to be certified by the International Mediation Institute. He has taught numerous workshops in negotiation and mediation at universities in Brazil, Russia, and the United States. Paul was also one of the non-government delegates at the signing of the Singapore Convention last year and has contributed to numerous discussions around the convention via presentations and publications. Welcome, Paul. Last but not the least, we have Dr. Sukhsimranjit Singh with us, who practices, teaches, and trains in dispute resolution. He is the Judge Danny Weinstein Managing Director of the Strauss Institute for Dispute Resolution and also an Associate Professor of Law at the Pepperdine Caruso School of Law. He specializes in cross-cultural dispute resolution and has numerous publications and presentations to his credit. Dr. Singh brings with him an extensive experience of mediating intercultural and commercial disputes in the US, India, and Canada, among other countries. He has trained numerous mediators across different countries and over 30 states in the US. I am fortunate to be one of his students. Dr. Singh is also an honorary fellow with the International Academy of Mediators, a council member for the EBA's section on dispute resolution, and a board member at the Weinstein International Fellowship Foundation. Dr. Singh, along with Mr. Paul, was also present as a non-government delegate at the signing of Singapore Convention. Welcome, Dr. Singh. It's a pleasure to have you. Now, without further ado, we'd like to kickstart with today's discussion. With today's session, we aim to delve deeper into the understanding of mediation practice as it has evolved over the past few years, the potential impact that the Singapore Convention is likely to have on the mediation practice. We are privileged to have panelists who will bring with them a multi-jurisdictional perspective on this. We'll also aim to better understand the interface between the arbitration and mediation and the parallel which is being drawn between the New York Convention and the Singapore Convention. Ultimately, we'll also give a closer look to some issues and key features of the Singapore Convention and understand them from a perspective of the Indian context. To start off the discussion, I would like to address one question to all of our panelists, which is to understand how the mediation practice has developed and how it has evolved over the course of their expertise or experience in mediation. Clearly, all of them have had long and extensive association with mediation, and we hope to understand their experience better in regard to their respective jurisdictions. Justice Kannan, if I may please request you to get started with the discussion.
Yeah, for the lovely introduction that you gave about me and about everyone else as well. You're addressing a question to a person who is 60 plus, and therefore I have fairly a large span of time to take in to survey the changes. Lots of things have changed actually in the mediation process at the time when I started, probably way back in 1977, in a place near Pondicherry, and yet another place was near Chennai in Tirupur. We had the involvement of local persons acting as mediators to secure an element of enforceability. Things changed in a very big way when the people's courts, or the Lok Adalat as we know, came to be established to settle certain types of disputes, more specifically about motor accident claims and some check bouncing, dishonor of checks and the action that you take. And then the Legal Services Authority, a statutory body, which is it brings about a new structure, brought them directly under courts. And they took in a lot of work relating to mediation, in some sort of mediation. And the Civil Procedure Code, the procedural law which drives all our litigations on the civil side, it was amended by incorporating change and introducing mediation as one of the tools of conflict resolution in courts, through courts. So we are talking about the court-annexed mediation. And later, the permanent Lok Adalats, the people's courts, provided for certain services to public utility services. And then it was a judgment of the Supreme Court, which I think was an important change, a game changer, as it were, for us in Afghan spalling. It gave a kind of a practical framework for how this civil procedure code provision has to be brought in. How do the judges make possible mediation to work through the lawyers? So it also examines some ethical issues about how a judge dealing with the subject of mediation, if he's not successful, he will not take the case on himself for disposal. So in the whole process, from where it started in Chennai in 2005, when Justice Kaju was there, and later when he went to Delhi as a Chief Justice, he took again mediation there, court-annexed mediation became popular, Allahabad then, and several other high courts, one after another, came. And in a ruling on judging on the validity of a provision, bringing some changes in the Civil Procedure Code in Salem Bar Association, the issue was seriously felt at the time we need some kind of rules and things. And the Supreme Court also at the time, Justice Lahoti was the Chief Justice. He established a Mediation and Conciliation Project Committee. So it was under them you had a kind of a syllabus drawn and some training to be done to the lawyers. So all these things came, and when this training came, persons from USA and UK came in a big way. USA, particularly from California, and from also from Philadelphia, probably from Washington, Geeta Ravindra would say. So there were persons who were training us. Many of the persons who took training were getting introduced to mediation the way it was practiced in USA. So that typical neutral way of doing things, not to be too evaluative, as was the penchant for a normal Indian practice of mediation. We were all introduced to different types and completely a fresh approach. I think many of the judges got trained, many of the lawyers got trained, and that's how I think the mediation of what we have in practice now is essentially driven through the kind of practice we were introduced through those trainers from USA. Lovely batch of persons we had. And now, as I see, when I was a judge, I could mentor quite a few of them. Every court had mediation centers established, and reasonably good lot of resource allocations were made. And what I see now, we're talking about how this mediation has grown. What I see now, there are a lot of startups, just not the lawyers, but technocrats, persons and engineers who establish conflict resolution portals. I know young lawyers and some engineers also, Pre-Sol 360 in Mumbai. They have some innovative manner of creating mechanism for litigation prevention, and equally low pricing, like an insurance premium payment to protect you against litigation. There is a clause like that. In Chennai, I have Just Act. Again, they apply AI tools to navigate negotiation and generate figures based on game theory when parties are haggling over numbers. So the presence of Mediation and Conciliation Project Committee, taking control of all mediation work, and particularly the court-annexed mediation, was necessary in the initial stage, but I'm not too sure whether its presence is itself the cause why private mediation is not taken up in a big way, because they are driven through some bureaucratic legal service authority and the way it works. I'm not really pointing out to anything seriously at wrong, but I'm saying private mediation is not taken up in a big way. But now I see that is happening. In the law which the government was looking at, where the Supreme Court was also trying to establish through a committee of experts, I had the good fortune to be there, just as you pointed out, Bhavya. And then we have everything in our mind, everything of what the whole world is looking at. I'll be surely excited to discuss with you what it's all about. So this is how I see the mediation as having grown in India, from what it was about 40 years back, where we started, to where it is now. That's my observation, initial observation.
Thank you, sir. That was really helpful. So you said that the Indian practice of mediation today highly reflects on what they do. To request Dr. Singh to add more to that, given he has worked in both the jurisdictions extensively, and we'd request him for his perspective on this.
Happy to, Bhavya. I will be brief, just to give everybody an equal chance, and it's such a pleasure to hear Justice Kannan speak. I have had a pleasure of meeting him in San Francisco before I met him in India, and he's an amazing personality, and you can see his wisdom flowing through his words. So thank you, sir. Pleasure to be with you, and so nice to be with Mr. Go and Mr. Mason, who are just world leaders in the field. So awesome. Lastly, I'll say quickly, Bhavya happened to be one of our best graduates of the Strauss Institute. We are so blessed to have you, Bhavya. So thank you for organizing this. And Dr. Kaur, Gurmanpreet Kaur, thank you for helping us with this session. And Mr. Mohit, thank you. Now, that was my cultural introduction. I'm born in India, so I'm still supposed to thank everyone before I start speaking. And what I would like to say quickly, and I won't take too much time, is it's a very interesting question. How has mediation changed what I've learned by mediation? And I have done some work internationally as well, and not just within US, in Canada and Australia and other regions. And here is my quick thoughts. Number one thought is mediation has become very legalized. In the last few years, mediation has being accepted in more markets. Arbitration has taken such a big scope of commercial dispute resolution that mediation became a little sister for many, many decades. So now, with thanks to, I think, to Singapore Convention as one of the needed instruments, because we need a lot more work, that mediation is now coming out to be as an accepted form for resolving commercial conflict. So I'm very happy with that. Now, I still think mediation is going to need to fight for a long time to come into mediation clauses in international commercial contracts. The clauses are still going towards arbitration. So if you look at a clause between, let's say, a bank in India and a bank in Singapore, the question is what clause those banks are agreeing to in terms of dispute resolution. Now, I know many of you know that many of Asian dispute resolution centers are promoting mediation. They're inculcating. I'm speaking right now from the Western Hemisphere perspective. In America, we have a long way to go to include mediation in that international arena. Within America, things have really done really well for mediation. So, a very quick snippet. In 1976, we had the Pound Conference that has really led to the mushrooming and thinking of this idea of mediation, amicable dispute resolution out of court. And I'm pleased to say that America has done really well overall. We have court connected mediation. Mr. Mason will add more to it. He has more depth knowledge in all of this. But I'm very proud to be trained as a civil mediator in America, as a family mediator, and now doing construction and commercial cases. And I'll tell you one thing, and including public policy, helping some city and state governments. And I can tell you in America, it is very well accepted. And thanks to companies like JAMS, which is Judicial Arbitration Mediation Services, AAA, American Arbitration Association, they have done their own work in promoting mediation as an amicable settlement, accepted settlement for commercial disputes. My last comment is with respect to teaching. One thing you will notice, folks, is there is more teaching of dispute resolution around the world, which is very good sign. You now have a center at your amazing Rajiv Gandhi National University of Law that I've had a chance of visiting many times. And the center is doing some great work, starting like this seminars. And this did not exist a decade ago, 2 decades ago, rather 2.5 decades ago in America. And this didn't exist 5 years ago or 7 years ago in India. So now India has the first master's degree in dispute resolution. So I'll end by saying the Strauss Institute, where I'm the director right now, has started more than 25 years ago, and we have trained more than 10,000 attorneys and judges in the US in mediation techniques and around the world, including 12 different countries. And what has been amazing to be part of the journey is to learn how mediation is growing. I'll end with this. We should not forget, mediation always existed. If you heard Justice Kannan, he mentioned lok adalats. He mentioned traditional ways of resolving conflict. Not just India, Asia particularly has a beautiful way of looking at conflict resolution, and we can learn from it. We will evolve as mediation is evolving. Thank you for this time to me. Bhavya, back to you.
Thank you so much, Dr. Singh. Francis, would you want to add upon the Asian perspective here? You've had considerable experience working with the dispute resolution centers, particularly in Singapore and other Asian countries. So over to you.
Thank you so much. It's a privilege to be among this esteemed panel and, to be able to present tonight. In Singapore, it is the night. So let me just quickly dive in to give a quick snapshot. When I graduated from the National University of Singapore in 1990, then got called to the bar in 1991, mediation in Singapore was unheard of. It was viewed as a sign of weakness if you had to settle your matter, because strong advocates argue in court and win cases. Then an interesting thing happened in about 1993 to 1995. The court started to experiment with a form of mediation called court dispute resolution. There was a pressing reason for this because they had what we call the hot wash, where we were trying to make the judicial system more efficient and to deal with a backlog of cases. So the court dispute resolution enabled a lot of cases to be efficiently dealt with and resolved. Then in 1997, the Singapore Mediation Center was established. I myself was trained and then accredited in 2001 and today serve as principal mediator. And then we had in 2014 the establishment of the Singapore International Mediation Center with a focus on cross-border commercial mediation. And then of course we have the Singapore Convention on Mediation now that has put a spotlight onto mediation. Now, what I've seen over these years is that mediation has gone from nothing to become grudgingly accepted. When I was accredited as a mediator in 2001, my friends laughed at me. They said, "Why have you gone soft, Francis? You are supposed to be this hard-nosed advocate. Why are you now talking settlement?" Well, I'm having the last laugh now because everybody is talking settlement these days as time and cost efficient. And now we've seen the advent of something called mediation advocacy. We are talking in Singapore about training young lawyers to be mediation advocates, not about advocating mediation, but how you adjust your advocacy techniques into a mediation setting so that you can advance your client's best case to win the case in the form of a commercially mediated settlement. And so then now we see the advent of community mediation, matrimonial mediation, employment tribunal mediation. You know, mediation has taken off in a big way in Singapore, and through the Singapore Mediation Convention, hopefully across the world as well, across jurisdictions. So that's my contribution. Thank you.
Thank you, Francis. So what I hear from the views that we have had so far is that court-annexed mediation has had a very vital role to play in all these jurisdictions. So Paul, would you please give your insights, given your experience working in the US courts and in mediation?
Thank you, everyone. First of all, I would like to thank the university and everyone who has put this together for an outstanding event and for the opportunity. And also thank my co-panelists for enlightening everyone about the status of mediation in their respective jurisdictions. I'm going to speak about two jurisdictions, actually. The US somewhat, and also Brazil, because I split my practice between those two countries. And Brazil may be relevant for India because Brazil and India are part of the BRICS, and they also engage in a certain amount of increasing trade. And here, mediation is a very wide subject. So I will confine my remarks to commercial mediation, more international commercial mediation, because that's the subject matter of the Singapore Convention. So certain things are excluded from that convention, like family mediation and employment mediation and those kind of things. So I won't address those because the convention doesn't. And my experience is more in the commercial area. I started dealing with mediation. The first case I mediated was in 1983. And I didn't even know what mediation was when I did it. And I was working for the public prosecutor's office. And it was a large environmental pollution case between 7 multinational oil companies and one community that had its groundwater polluted. And by doing things in various improvisational ways, we were able to reach a settlement of that very complicated, sticky case. Later on, I was walking down the street to the law bookshop, and I saw a couple of titles saying mediation, how to resolve your issues. And I said, wait a minute, I think I just did that. So I bought the book, and then I started reading, and I got more interested. And I worked on a couple of projects, one with the Harvard, at that time it was called the Harvard Negotiation Project in the 70s and 80s. And I see it from the US perspective. I think Dr. Singh has hit the nails right on the head. You know, I see mediation starting to take off in the US more in the academic and other areas in the 70s. And came getting to yes and started getting a little bit popularized with that book and that line of thinking. I think that it is doing well in the U.S. JAMS and the American Arbitration Association, I would say, are the institutional leaders for private mediation. We do have court-annexed mediation, which is, I don't know if anyone explained it. I'll try and do it in a couple of words. It's where the courts offer mediation in cases that are in the courts. That is, not all cases, just the ones they have, right? But they don't control all the aspects of how it's provided. Some of them, in some courts, it's mandatory to try at least once. I think as of 2012, if I get the statistics right, 62 out of 93 or so U.S. federal district courts, not the state courts, but the federal national ones, required a mandatory attempt, at least one shot to try it. But the courts don't run the mediation. They outsource that to private mediation practitioners and institutes and the like. Where I'm based in Florida, that's what we have, what I described. And it has been getting traction in the U.S. I was corporate counsel for in-house counsel for large multinational IT companies for almost 20 years, and I was trying to insert the kind of clauses that Dr. Singh was referring to in our commercial contracts. And first, I got the most pushback and resistance from our own litigation lawyers, because they're used to going to court, and especially for IT, the U.S. courts are considered pretty good. But then I would always say, "Oh, that's great. The U.S. courts are very, very good. But what if you win and you try and get that judgment enforced outside the U.S.?" And then people said, "Oh, yeah, that is a problem." And a lot of countries won't recognize that, no treaty or that type of thing. So then people started looking at arbitration when they wanted something binding, and mediation as a previous option. So I started inserting these kind of meet-arb clauses in the contracts already in the 1990s. And they're taking off more now. I think the mediation in the U.S. is doing well. I think the Singapore Convention, will get to it, but I think the Singapore Convention will have a very positive impact on corporate counsel and internal in-house corporate lawyers who choose these clauses most of the time in the contracts going out of the company to include a mediation phase. And the enforceability, which the Singapore Convention will provide, should encourage the corporate counsel to do so with a lot of seminars like ours to help educate. Now, Brazil is a different kettle of fish. Brazil has a very interesting, ironic, dualistic situation. Brazil is very well known in the world as a country that on the diplomatic level has mediated many and resolved many just diplomatic and military disputes, both in the Western Hemisphere and elsewhere. So it has a reputation in its diplomatic corps for being excellent mediators. But at home, internally, the court system is very complicated. Brazil is a country with 210 or so million people, which for India doesn't seem like a whole lot, especially since Brazil is probably 20 times bigger than India in size. But they also have 120 million court cases ratio for the number of people it has. And many of those come from the public sector, actually, not even from individuals. So mediation is being considered, and it didn't take off in Brazil for a long time. But in 2015, Brazil did pass a mediation law. And this law wasn't the world's best law, like sometimes first efforts and everything, you have to learn from experience. But it did do a couple of things. The most important thing it did was it authorized mediation by public entities. Before that, if there was a dispute with a public entity or public entities, a lot of these 120 million cases have public entities as party. So this is a big thing. So before this law authorized, public entities wouldn't mediate because they said we're not authorized by law. It's a country where the public sector, they have to get the rubber stamp imprimatur before they'll do anything. So now they're starting, that was 5 years ago the law got passed. And now there's seminars and people are taking these things to the public sector, public electric companies, things like that. The public sector does a lot of things that in countries like the US, the private sector would do. So it has an economic impact, is what I'm saying, and internationally as well. But it's taking time. There's a certain resistance among private lawyers to mediation, especially the smaller ones that are more used to and trained in litigation. So the big law firms, the international law firms in Brazil, they like mediation because they want to keep the client satisfied, and that's the main thing. If the client gets a settlement and they avoid litigation, which takes often many, many years, take 15, 20 years to get a resolution with all the appeals they have there. So to summarize, the U.S. is in a pretty good place, as Dr. Singh said. It can grow more in the corporate world. And Brazil has a steeper ramp to go. But some of us are working on that and hope we can move it forward with the help of the Singapore Convention. Thank you.
Thank you, Paul. So Dr. Singh, earlier on you reflected that Singapore Convention is one of the key instruments that was needed to give an impetus to commercial mediation worldwide. So I would like to request your views on understanding what the convention aims to achieve, and if you could probably reflect upon the discussions that happened at the signing of the convention last year.
That's a heavy question. I will do my best to give my perspective, but I do think Paul and others may like to comment. And my quick answer, if you may, or a brief answer, I should say, is first of all, we have to understand a couple of things basic about this convention. The first one is this is a post-mediation convention. This convention discusses what happens post-mediation, and which is, so we have to define what mediation is now. So Article 3, Clause 3 defines what mediation is as per the convention. And let me read quickly what the Article 3 says. It says, mediation means process irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons. Then it says, lacking the authority to impose a solution upon the parties to the dispute, which is very interesting. This third party, as per the convention, should lack the authority to impose a solution. So in this definition, the convention is separating consciously arbitration, judicial decision-making, case settlement, med-arb, and all those processes, and saying mediation we are focusing on is a facilitative dispute. I just want all the young students there to be aware of that this is, I think it's a good promotion of facilitative model of dispute resolution, which is mediation. Number 2 comment. When I say post-mediation, it digs deeper into defining not just what mediation is, but beyond the definition, what it tries to do with mediation. So I have a very simple comment here, and I want to hear what Mr. Mason has to say. And that is this. I think what the convention is attempting to accomplish is the following. Number 1, it is attempting that mediation becomes more recognized worldwide. The biggest thing, the biggest goal of this convention is awareness, recognition, and acceptance of mediation, especially in the global business community. That's my humble opinion. I hope I'm not wrong and my panelists can correct me. Number 2, I think what the convention is trying to do is change the mindset of stakeholders. Now, my colleagues, especially the younger ones, you understand stakeholders are key to bring any change in life, in any organization. And let's quickly see who are the stakeholders here. We have, number 1, attorneys, lawyers, advocates, called differently in different countries, right? Attorneys, lawyers, advocates. This community is very critical for the success of commercial mediation because in many, if not most, commercial mediation cases, parties will be represented by an attorney, local attorney, most likely. And that attorney needs to be aware of Singapore Convention, aware of the cross-cultural nature of how this convention is promoting mediation. Number 2, is judges. You know, folks, I wish we had more justices like Justice Kannan. He is, I'm a big fan of him. And Justice Krishnamurthy is just, you can see he is promoter of mediation, of dispute settlement. He's a very humble judge. He loves to learn. He's still learning. He's still teaching us. And we need judges who promote mediation. I think convention will put a dent in those judges who think there is no future of ADR, there is no future of mediation. Now we're all waking up and thinking, oh, you know, maybe there is future. Okay, stakeholder number 3 is legislation. Remember, the convention is signed by as many countries as possible. It has to be ratified. And then, as you all know, you must understand through treaties, the law of the treaty, there is not just one process of ratification. Every country ratification is different. In some countries, you have to go through 3 processes of ratification. And one of the places where ratification stays is legislation. Therefore, legislators become the stakeholders. And the last couple of them, there is business community. If the Tata, Birla, if the Apple and Samsung and Boeing don't wake up to the call that disputes can be settled amicably and through their attorneys, through whoever, through mediation, then the convention is going to fail. I don't think it will, but I'm just saying the business community has to accept it with open arms. And the last couple of people you want to think about is law firms, which I don't doubt that they already are opening up, and the non-government sector. So I will stop here. I just want to introduce my thinking on how the convention can be accepted, can be embraced, and how the stakeholders will play a big role on what the convention is trying to achieve in this post-mediation place where the enforcement is a big deal. Paul, anyways, I'll go back to you, Bhavya, sorry.
Thank you, Professor. Paul, we'd like to hear from you as well, given you were there at the signing. Let's build on to that.
Well, thank you very much. It's hard to build on to something that was so well presented. I completely agree with Professor Singh. I would add a stakeholder or sub-stakeholder, which would be the public sector, especially in countries like Brazil, where the public sector it's part of the business community in so many economic sectors of activity. So there's a political aspect to that. It has to be baked in as well. I think one interesting thing is about the ratification and also the judicial role. For example, I was in San Francisco speaking at a conference on U.S.-China dispute resolution last June. And this was before the Singapore Convention, but people saw it coming. So I met one of the Chinese delegates there. And we started speaking, and I said, well, what do you think China is going to do about the Singapore Convention? He said, I don't think China is going to sign it because we don't know how we're going, if we signed it, I don't know how we would be able to actually implement it in our courts or whatever once enforcement measures came. So then I said to him and my co-panelist, who was a U.S. federal judge, we both said to him, nobody knows how they're going to implement it right now. Don't worry, that's why there's a gap between signing a convention and ratifying it. And during that time gap, that's when each country has to look at its own judicial system and see which is the best way to take the convention measures into the courts. I know that Brazil, for example, they have a very good way for arbitration. It took them some years to develop it, but they have a very strong way of enforcing New York Convention awards, foreign awards under the New York Convention in the Brazilian courts, which is not easy given the huge number of cases they have, as I mentioned. Every country will have their own way. And I think one strength of the Singapore Convention, if I could just build upon what Dr. Singh says, that it didn't try and regulate all those things in all the different countries. It realizes the diversity of legal, cultural, and business practices in all the different countries, and doesn't try and over centralize it. And the last thing I would say is that one beauty of this convention is, as Dr. Singh said, it doesn't touch mediation itself. It's not a mediation convention. It's a post-mediation convention if the mediation succeeds. And not any mediation, it's an international commercial mediation. So it's fairly well focused in that area. But for people who say, well, it doesn't cover all these areas of mediation, doesn't provide all these safeguards, it does provide some minimum standards. There's one clause, one section that says, you know, you have to have minimum capacity to mediate. Well, a 2-year-old can mediate under the convention. It's just that any settlement agreement signed by the 2-year-old or their representative wouldn't be enforceable, but that it could still mediate. It doesn't touch the mediation process really, except for these minimums. So that's what I would say right now. Thank you.
Yeah, thank you, Paul. You briefly touched upon how the Brazilian system has evolved in regards to the enforcement of arbitral awards under the New York Convention. Having said that, there's also a lot of speculation going on between, and there have been analogies being drawn between the New York Convention and the Singapore Convention. So, Paul, would you be able to throw some light upon that and express your views on whether this is the right path we are going on?
Oh, thank you very much. I'll try and do so succinctly. I actually think, you know, arbitration is a binding process, and mediation in itself is not a binding process. We'll start with that. The parties are only bound if they sign a settlement agreement, and then the question is, how is that going to be enforced? And that's where the New York Convention has arbitration, and Singapore Convention has mediated settlement agreements. I actually think the mediation convention, possibly for these reasons, are the differences between arbitration and mediation, and also because of the practicality of the drafters, is designed to be more flexible and more easy to apply and enforce than the New York Convention is for arbitral awards. And I would, without making a lecture out of it, but three respects at least, and then one similarity that is positive. So unlike the New York Convention, the Singapore Convention does not require any formal recognition of the instrument that's being enforced. The New York Convention, many countries require that the arbitral award be formally recognized, some in the courts of their own country before you can bring it to the enforcement country. Brazil used to require that. Colombia still does. There's different, that delays the enforcement and it formalizes it, and arbitration is a more formalized legal process. So, okay, I'm not saying take it out of the New York Convention, but maybe you should, but at least I'm glad the Singapore Convention doesn't have that. It actually, all that is required under the Singapore Convention is an evidence that a settlement agreement in writing, which includes electronic format, which is great these days, that exists, that it covers international commercial matter, that the text itself of the agreement doesn't have to be presented, unlike the New York Convention where you have to present the award. Just the fact of it has to be shown. And the fact that it has to be a mediated one, not a directly negotiated one, but a mediated one, right, in order to qualify. And the mediator, this can be shown in several ways. The mediator can sign it. Many of us as mediators tend not to like to do that, to sign parties' settlement agreements. Or the mediator can sign a simple statement saying, I, Paul Mason, mediated a commercial case between Company X of India and Company Y of France. They settled it in a mediation, period, date, signature. Or a third option is even that if the mediation is done through an institution like the ICC, International Chamber of Commerce, or the JAMS, or the AAA in the US, the institution can send a form letter saying, oh, this case was mediated on such and such a date by mediator X, and they reached a settlement. Okay, that's the first more simple way, the simple procedure of the Singapore Convention than the New York Convention. The second one is signature. The Singapore Convention can be signed anywhere in the world. As I was joking to my colleagues the other day when we were doing the dry run, it can be signed by the parties on the North Pole, you know, or the South Pole. It doesn't have to be a convention country. It can be any place. What counts is when you try and go and enforce the convention there, and then you have to go to a country that has ratified it in order for the convention to have teeth, right? Okay, and the third thing, unlike the New York Convention, the text of the New York Convention actually doesn't have this, what we call reservation. But there are reservations allowed to the New York Convention signed by the majority of the countries, which say that reciprocity is required. In other words, in order for an arbitral award to be enforced under the New York Convention in country A, the party coming from, say, country B has to also ratify the New York Convention in order for the citizen or a company with a base in that country B to come to country A and try and enforce the award under the New York Convention. And bearing in mind that country A, the country where enforcement is sought, can be any country that is ratified it, and hopefully where the non-complying party to the award has assets. You know, it doesn't make sense to go somewhere where the party in default doesn't have assets. So in the Singapore Convention, no, they don't. There's no provision in the text or a reservation permitted for reciprocity. So basically, anybody can come. They can come from the South Pole. They can come from the North Pole. They can come from countries that haven't ratified the convention. There's still some, about 2/3, that haven't signed it yet. So there's not that restriction of reciprocity, which makes it a whole lot easier to apply, in my opinion. And then like the New York Convention, as I said, to wrap it up, you can go as a party seeking enforcement of your mediated settlement agreement. You can go to the courts in any convention country to take measures to enforce it, which usually means attaching, freezing assets of the non-complying party most of the time. Thank you.
Thank you so much, Paul. Francis, could we have your quick comments, additional comments on the same?
Yes, thanks. I think Paul has given a great summary of it, and to which I'd just like to add two quick thoughts. If we compare the two conventions, I think what Dr. Singh was mentioning about how it's a post-mediation focus, I think that would be a great phrase to guide us as we seek to develop the ideas or the spirit behind this convention. The fact that there's no reservations or reciprocity needed, like as if it was in the New York Convention, is also key, because essentially what we now have is recognition that commercially settled agreements can be enforced across jurisdictions. This convention now makes real the possibility that you could use your settlement agreement like a sword to enforce it across jurisdictions. Or it could be used as a shield where you are trying to say, no, you cannot sue me now. You cannot reopen this case because we signed. To use Paul's example, you can't go to the South Pole and reopen or relitigate because I can invoke the defense of the settlement agreement signed in the North Pole. And I think this opens up a whole wealth of possibility for mediation to be adopted in various jurisdictions. The limit is only in our imagination and in our will to make this a reality.
Thank you, Francis. That was indeed very helpful. For the better understanding of our attendees, it is very important for us to discuss the development around Singapore Convention in the Indian context. So my next question is to Justice Kannan, and I want to better understand from you how is the jurisprudence around the Singapore Convention likely to evolve, especially keeping in mind that the jurisprudence around the New York Convention and enforcement under it thereof took a considerable amount of time to take off.
Yeah, just now Francis gave a wonderful imagery of the sword and the shield of how you can use the settlements which could come about through this convention. We have had quite a problem about enforcement of awards. Arbitration awards had been major issues for us. We had before 1996, which was driven through the UNCITRAL model law. We had for international commercial arbitral awards, we had to secure it through the Arbitration Protocol and Convention Act of 37 and Foreign Awards Recognition and Enforcement Act of 1961. It was as early as that. But our problem at all times in India about enforcement is in a very strange way. There were too many interventions by courts. Excessive intervention meant that you have an award, you make a challenge to a court, it operates as automatic stay. So therefore, when you're talking about enforcement, where if you're looking for courts as the enforcers of those awards, courts were themselves reasons why awards could not be enforced, because you need to just make a challenge. It was a matter of routine that it will be brought on your file if it is numbered. If it is numbered, that's all. It's all stayed. So these were very serious. And there was now a fresh look into things, and there have been changes now in Indian law in 2015 and 16 that it cannot operate as automatic stay merely because you file a case. You need to be, again, very restrictive about the grounds of challenge. Unlike even awards where somebody else takes a decision, there are settlements which are brought by the parties. Therefore, there needs to be very clear areas of how the party's decision gets empowered, and it's not merely stopped somewhere. But some of our legislations had very funny approaches. In the Companies Act in 2013, the provision that talks about mediation in 443, it contains a subclause. After a settlement is done, any one of the parties may say in the court as to how it cannot be enforced, how there are problems about it. You bring immediately along with it a provision that you can challenge it before the tribunal makes a finality on what is settled between parties. It can be a kind of challenge. So therefore, the approaches have been, in some way, they've not understood what a settlement could mean. Now, I think Singapore Convention makes that very clear, that Article 5, where the grounds for refusing a grant of relief. So it's very clear in its expression. It says now party is under some incapacity, such as when a person is insane or a person was young in age, can't have. So that's a very clear thing. Anyone can see on the face of it, there's an incapacity and therefore you can't enforce it. And it is null and void. For what reasons? Again, it's under the law where it is sought to be enforced. That which is taken is a clear, unavailable relief. It's not possible. So now it's, or in the way it is drafted, it's not yet final. It's only, it's not binding, it's not final. It was merely declaratory of something that was not final. And then, or a situation where there is already, like what Francis was saying, you can use it as a shield, he said. But even as a shield, somebody can say, now, it is not yet complete. We have entered into another transaction. This is not the one which you can enforce. It is something else which has come about. So, or it is incomprehensible in its terms. So now the definiteness of what has come through, what can stay, what can be enforced or what cannot be enforced, or what comes through this Singapore Convention, I think that's a great start. Because hitherto our understanding is like judgment which is appealed against. If an award, it's you file a case and then stay things. Settlements can't take the same way. They will have to be recognized, and the limited window through which you can see those grounds available for you to resist an enforcement. I think that is the big benefit which the convention gives to us. And if there is a law made, it has to be, that's what, again, we were attempting to look at framing of a law and recommend to the government. And we have seen that it was so easy an exercise for us to simply lift what was there available through Article 5 and then put it there and say, no, these are all the only grounds. So the enforceability ought not to be a problem. This is what it is. And that is what is going to be there across all those countries which sign. And that's how we'll have even uniform methods of application, of enforcement, of resistance to enforcement. So I think that way, the area of enforcement, which had been a problem or whatever, or the areas where there are roadblocks, all that is cleared now. And I'm sure if a law comes to place, we will be having an enforcement in an easier way than what it was before.
A follow-up question to that. In the Indian context, do you think that the Singapore Convention, with its limited scope, or wherein it covers only commercial disputes, could come as a challenge? I mean, specifically because privatization of mediation in India is not really picked up, and a majority of disputes still arise from the family and personal matters.
If you're talking about, are you addressing that question to me, Bhavya?
Yes, please.
Yeah, so I don't see the limit of enforcement of what you say. See, that limit of what you see probably under Article 1, it says, like what Mr. Singh pointed out to us, there are certain things which it will not touch, like court judgment. So therefore, we are talking about the exclusion, the limitation of what it says is settlement agreements that have been approved by a court or concluded in the course of proceedings before a court. If it's a court judgment, it is the court which has to be seen. If it's a judicial settlement, even there in Indian law, in the procedural law, we have mediation, arbitration, mediation. Judicial settlement is seen as a separate category. Therefore, I don't see that kind of a limitation is ever a limitation in that sense. It is the right thing to do. It is for the courts. Those court settlement we are not talking about now. We have no touch on that. And also the enforceable. Another limitation of what the Act gives is they're enforceable as a judgment in the state of that court. If it is a judgment that is going to be enforced in the court right away, it is not going to be seen as a settlement of what we are talking about. Therefore, those exclusions, those limitations of what the Singapore Convention says are most natural things to have. Otherwise, there can be quite a problem. You can't mix up these things or whatever. Then that's exactly what I was saying. If it's again to be interfered and seen as a judgment, there'll be appeals, there'll be challenges. That kind of a thing we can't afford. So the limitation of what you find here makes enormous sense. And we're again making a point about some of those settlements of what are here and mediations mostly happen in some areas of matrimonial matters, succession and things that are excluded, is what he pointed out. You must know something. It is not without reason that you have those exclusions. It's essentially seen. Singapore Convention is seen as empowering a business community. Commercial mediation must work in a big way, where inter-country transactions happen in a big way. It should be handled in ways that there are mechanisms available for you to resolve the disputes and they don't escalate to court litigations and take a long time. If there are issues of in matrimonial matter, for instance, I can immediately think of an illustration of what in USA, through a 2015 judgment of the US Supreme Court, same-sex marriages become possible. Let's assume that therefore there is an Indian there settled in the US and another person there. Another person is another of the same sex. And they have a settlement somewhere and one comes away here of one dying and then asking for enforcement for succession, or another person going and seeking for restitution. If there is a settlement having affected elsewhere, and we are going to bring it to another country for enforcement, where there could be a very serious change, or what we are seeing in commercial contracts, where you can find enormous homogeneity of approaches. These are the tricky issues of succession or matrimony. These are areas where that kind of adaptability and homogeneity will not obtain. But all the same, having said that, I must say, in the draft legislation of what we have presented to the government, there's nothing a national secret. Therefore, I can say that we had, because Singapore Convention does not say these signatories will not have in cross-border mediation, issues relating to succession or matrimony matters, because that is still a problem. Custody issues are major issues. Somebody coming away, getting married there, having a child there in USA, and coming away, taking the custody child here, and then a case here in India, case here there in USA. There could be serious issues. So therefore, we have said it is we will have even in this cross-border mediation, we will have issues of custody, matrimonial matters will also be there. So therefore, there are some limitations. You must understand that those limitations will be really meaningful matters relating to succession and other things. But it doesn't really mean that issues of matrimony cannot be an issue where domestic law can provide settlements taking place in a cross-border settlement can be enforced here in another court. A custody issue of what has been resolved by parties can still be enforced and given effect to in another country. But at all times, matters relating to custody, and the court as a guardian, as in its capacity as a patriarch parents, will always decide on the welfare considerations, irrespective of what the settlement is between parties. So there are some small changes will have to be understood, and they are acceptable right through the world. So those limitations of what you see, there are purposeful limitations if they exist, and they are not anyway irreversible things. It's all possible for the signatories to modify reasonably. Back to you.
Thank you so much, sir. Dr. Singh, could we please have some of your comments on that?
I don't know if I can follow up with that. Justice Kannan did a beautiful job and covered everything. I'll only speak for 30 seconds, and I'll better time myself this time. And I'll say this. First, so it was all covered, and I'm just going to repeat my lordship's couple of comments. I love the word he used, empowering mechanism, and I want us all to really think about that. I think that's a beautiful summary of what the convention is, empowering mechanism. I don't think it's a fight between, oh, the convention is only doing commercial cases, we do so many of family cases, social cases, this is not applicable, what's going to happen? I think we have to switch that mindset and see the convention actually, oh, wow. So Singapore has actually become a leader in the world, if you may, in mediation, in civil dispute resolution settlement, came up with an excellent instrument that is guiding us to see mediation in a new light. That's what it is. What's beautiful about the convention is, unlike New York Convention, which all of us know is an arbitration focused, Singapore Convention does not require formal recognition of the convention, of the instrument, to be abided by it. And that's beautiful. Like, you don't have to be a citizen of Singapore, you don't have to be a citizen of India which signed the convention. You could be any of the world countries member and still try to abide by the Singapore Convention. Now that is itself a big, what I will use the word, promoter of mediation. I think the convention is promoter of mediation. So it is, last thing I'll say, Bhavya, and that is, unlike, well, I shouldn't say unlike New York Convention. I think New York Convention tried to achieve this as well. They both try to be consistent with the local court system. That's where Justice Kannan was going, that nobody's taking away your local right to go to a court, and that system is going to exist. We cannot change it overnight. India has a very dense, complex, amazing court system. We have issues, of course we have issues, but are there judges who are honest and who are taking up more cases than any other judge on earth? Yes. Are they doing very hard work and giving justice? Yes. Are they doing mediation? No. They are traditional judges. So we have to be consistent, I think, with that local way of giving justice. We have to walk in sync with it. And I think that's what the convention is trying to teach us, is here, this is what we did. It's an example. Now do what you can do in your local systems. I'll stop here. Thank you for the question, Abha.
Thank you so much, Professor. That indeed provides us more clarity about what we are aiming at achieving and how the whole scenario is going to probably look like in the Indian context. Another beautiful thing that I picked up from Justice Kannan said was that there are purposeful limitations to the convention. And specifically in that regard, my next question is to Francis. Given that Singapore Convention does not cover under its scope ARB-MEDAB approaches or MEDAB approaches, how do you think is there going to be the significant value addition from the Singapore Convention?
Thank you. That's a great question. And I think I would add one more adjective to follow up from the beautiful examples of Justice Kannan and Dr. Singh. And this is the word complementary. All right. The way the Singapore Convention on Mediation has been crafted is to put mediation as complementary to the court system in any given jurisdiction. It's complementary to what the New York Convention has achieved through arbitration. And it is actually saying, I am not taking away, I'm not competing for the jurisdiction. I'm merely saying that now mediation is recognized as another legitimate form for cross-border commercial dispute resolution. And I think, to borrow Dr. Singh's eloquent, adjective, that is empowerment. And really, therefore, it is about how each jurisdiction can now look at mediation again with fresh eyes and say, we've got now a dispute resolution mechanism that is conciliatory. It has party autonomy because parties can opt into it. It's less adversarial because you have a neutral that's helping to facilitate the communication. And yet, when they have arrived at a solution that both parties buy into, there is a certainty and finality because there is now the possibility of cross-border enforcement. And that is empowerment. That is complementary of the efforts that parties are trying to take to manage their disputes in a time and cost efficient manner. And I think the idea here is that now parties have options. You go to the local courts, you go to arbitration, and now you have international mediation. I'll stop there. Thank you very much.
Thank you so much, Francis. That was very helpful. Building on that, we have understood that yes, Singapore Convention aims at empowering mediation as just another mechanism to resolve disputes. In that particular regard, I would like to ask Paul, what are the benefits that we could derive from institutionalization of mediation? Paul has had extensive experience of working with different CADR institutions, and we'd really like to hear from you regarding that.
Oh, thank you very much. We're talking about the institutionalization of mediation. May I assume, Bhavya, that you mean mediation that is administered by ADR institutions and centers, chambers of commerce and things like this?
Yes.
If that's what you, okay, I see your head nodding positively. Well, I think the best thing that institutions can do for mediation is to promote it. I think the main thing for me, I've mediated cases under ICC and under American Arbitration, International Center for Dispute Resolution, rather, for Brazilian institutions. I think the main thing the institution, let me put it two ways. There's a promotional function in that when parties are thinking ahead, how, especially the international commercial space, which is what the convention is involved in. Most of the time you have pre-existing contracts, and most of them are drawn by lawyers, not all, but some. And these lawyers, many of them are transactional lawyers. They're not dispute lawyers in the beginning, before the dispute happens. Then they may not know that much about the benefit of mediation. And institutions, which now have maybe local but have global reach thanks to the internet and other things, can help promote the mediation. They can also educate both the parties and clients about what mediation is and how it works before they actually start the process. So, for example, in Brazil, I'll take a Brazilian example. They have something called pre-mediation. So what is pre-mediation? Pre-mediation is they call the attorneys for, say it's a simple two-sided case. They invite the attorneys and their party clients to come to the center. We're now in the days of COVID-19, maybe participate in a video call. And the people from the center, the administrators, usually not the mediator, sometimes it's before the mediator is even selected, go through what mediation is, how it works, and answer questions, especially from business people who are not always so familiar. I think that those are things that you wouldn't get in an ad hoc mediation. Ad hoc means the parties themselves arrange. I've done several ad hoc ones with Russian parties. I've done 2 or 3 with Russian parties, and I don't know, maybe whatever reason they liked ad hoc mediation, and we resolved both the cases. But I think the institutions can provide value on the front end, is what I'm trying to say. Once you're in the mediation, then I don't see a lot of institutional value there. I see more in the front end than in the meat of the mediation. Thank you. I hope this is helpful for the audience. That I may be alone in that view among my colleagues, though, but that is my view, and that's the experience I have.
Well, thank you, Paul. That was, and I am mindful of the paucity of time, and I would like to reserve some time for a couple of questions from the audience as well. So moving on to the last bit of it, if we could have quick thoughts from all our panelists about the role that young professionals can play in regard to promoting mediation across the world. Can we start with Francis, please?
Thank you very much. 3 quick thoughts. A quick thought that goes from the institutionalization question that Paul was talking about. I think it is healthy for mediators to be organized under institutions, and I can think of immediately 4 benefits. There's the promotion element that Paul was talking about. There is also the training element, an accreditation element, and perhaps a maintenance of standards. So for example, the Singapore experience has been the Singapore Mediation Center that has actually kick-started the whole process of creating the awareness of mediation. And then as we went into the international arena, the Singapore International Mediation Center promoted this whole idea and trained mediators as well in readiness for this development. And so what can this mean for the young practitioners? You need to prepare yourself for this movement on 2 fronts. You can either contribute as an accredited mediator, where you are then part of that process to facilitate that mediated amicable settlement. The other aspect is be trained as a mediation advocate. It doesn't mean that just because mediation is gaining traction, that your advocacy skills are thrown out the window. You now need to adjust or reorientate that advocacy skills, where previously you were pushing a position and trying to get the best deal for your client in the form of a judgment. You now have to use your advocacy skills to promote interest, how parties can then enhance their relationship and achieve an amicable solution as they move forward. These are my quick thoughts. I hope they are helpful.
Francis, over to you, Justice Kannan. Sir, I believe you'll have to unmute yourself.
Yeah. Am I there? Yeah. I would take it the same way as Francis did, that from institutionalization to improving the skills for youngsters. The arbitration, when we talk about wanted to institutionalize and improve arbitration and make it an important global hub, India is a global hub, Sri Krishna had this recommendation. He said we need to have an arbitration council which will accredit, which will secure the standards. So therefore, when you're talking about standards, and again, I know, meet with young lawyers in college campuses, many of them, they're not interested in litigation. Litigation takes a long time. It's anyone. That's the way he feels put off. And then again, he knows he waits in court endlessly than productive work. That can be another serious dampener. So therefore, there is something interesting to offer right now. That should start at the college campuses. I've known Mr. Sukhsimranjit taking his students across the continent to places where they field the students for negotiation competition. It's just not moot court competition. There are negotiation skills, which are new skills. There are new skills to be developed. And that is what really helps in mediation. So a person, as soon as he comes out of college, he may not be a mediator yet. It would require some baldness or some gray hair to come. Not necessarily, though. Wisdom comes even early to many of those young children, I'm sure, young students. But I'm saying to start with, I think mediation attorneys, they come with different skills of negotiation. Therefore, how do the students get interested? I would say we will have our colleges, institutions teaching us different skills of negotiation. And then we need, Mr. Mahajan used to be saying, the late lamented Mahajan, who is the Vice Chancellor of repute from the Bangalore School and later established in Calcutta, and he was also a director. He would talk about the need for having, like a bar council, we need a mediation council of all mediators joining together. So at all times to discuss what should be done, how do we improve quality, how do we see that this knowledge is disseminated amongst all sections of people. Right now, the project committee, our Supreme Court Engineer Committee, it talks about mediation to be taught to persons who are 5 years, 10 years. That's the way it is. If they are trained mediator, if you have to be a mediator, 10 years of practice. And in some places it has been reduced. So it could put off students, but I would think that there is some other activity which they could be actively engaged in if they are there in mediation arena, such as negotiation. So therefore, these, I think, are the ways you can make mediation work and then get youngsters get interested in this. Yeah, over to you, Bhavya.
Thank you, sir.
Bhavya, are you asking me or Mr. Myth?
Are you on mute, Bhavya?
That's the thing, but either of you can take it up first.
Go ahead, Paul.
Okay, thank you, Professor. You were very courteous, a real gentleman. I appreciate that. First, I just wanted to say, when I was asked about institutions, I may have interpreted the word a little bit narrowly as those that actually administer mediation cases. And that's what my remarks were limited to. After hearing Francis open that definition up, which was very good, I think that institutions have a great role to play in accrediting mediators. I work with the IMI a lot, the International Mediation Institute, and that's what we do. And one thing that I would expand on what was said by Justice Kannan was the idea of competitions. There are actually mediation competitions as well as negotiation competitions, and sometimes they go together. I participated, my wife, who was a Brazilian mediator, my wife and I, we were expert assessors. That's the word they use for judges. In a very excellent one in Goa in 2017. So that was our first trip to India. And since then, we've been back one time. And then there was one in Vienna, which is well known, the PIAAC competition, which is held every year in Vienna. And that's where I met several Indian law student teams and their coaches, which are professors, and young Indian attorneys who were working as staff on that. And we've also judged ones in Brazil, 2 or 3 in Brazil, and 1 in the US. I think this is a great way for law students and young lawyers to get their feet wet with mediation and see how it's working and get good feedback. The idea of the judges, for us as judges, is not so much to give a score number, but to give feedback to the students about how they can improve, especially since it's a subject that's not taught in law schools all over the place, except for the better ones like Pepperdine in the US, but that's growing. So that's what I would add to the conversation on that topic. Thank you.
Thank you, Paul. Over to you, Professor Singh.
Absolutely. I knew he's gonna say something amazing, so I wanted to hear that first. I have 4 questions that I'm gonna leave you with, and that is, will this convention remove inequality in access to justice? If not, then what do we need to do to remove inequality to access to justice? For example, it attaches to my next question. Will this lead to major players controlling the market? Which is connected to my next question. Will this lead to a diverse panel of mediators around the world? Panelists like Mr. Go, Justice Kannan, like myself, like yourself, Bhavya, right? Like Paul, instead of just belonging to one culture, one race, and one majority. And how do we do it? So this is the starting place. There's a lot we need to work on to fight, to get a cross-culturally competent crop of mediators, to work with them to get that skills, and to make sure that they're represented at the international stage and not ignored just because they're women, or just because they wear a turban, or just because their name is difficult to pronounce, or because they're Indian, Asian, Singaporean. So that's my dream, is this convention leads to what arbitration did not bring us. And I think I'm pretty clear with my last statement, what I meant with that. So I hope that's my dream, and that's my, because I'm really sad to not see many arbitrators in international commercial arbitration that belong to the place of my my home, India, and it's not because Indians are not good arbitrators. It's because the system has somehow come to a place where it's just so difficult to diversify the profession, and now we are doing a back end job. It's such a pleasure to be with all the speakers today, Bhavya. Thank you for inviting me. Yeah.
Thank you so much, Professor. And your questions have left us with enough food for thought for today. And thank you for that. And thank you for all the encouraging words from our panelists for young professionals like myself. I would still quickly like to take a couple of questions from the audience. I can see one that's addressed to Francis. And it says that with India and China signing the convention, can it be said that they will take Singapore as the mediation hub in Asia, given that their enormous economic growth and the great number of cross-border transactions they're involved in?
You know, I think the great thing about the Singapore Convention on Mediation is that it allows parties anywhere in the world, in any jurisdiction, to come together, resolve their disputes in a time and cost-efficient way, unlike the arbitration, which requires a seat. I think in that sense, mediation is more global. So I think what the Singapore Convention on Mediation has done is to empower all of these jurisdictions, all of these stakeholders, to use that lovely word that I heard earlier in the course of the panel discussion, to encourage them to come together to resolve their disputes. And it doesn't have to be in Singapore. But what they do have the assurance is that if they need to enforce it in Singapore or have it recognized in Singapore, the convention has provided the foundation for that. Or likewise, if they had to enforce it in any other country in the world, the sword and the shield imagery, I hope that encourages everyone to, take up this mantle and have that global access to justice that Dr. Singh was talking about. And we have this great level playing field for everyone.
Thank you, Francis. I'll quickly take up one more question, which is addressed to Justice Kannan. And it says, can we expect the mediation legislation in India to be a comprehensive legislation regarding domestic mediation as well?
Yeah, I wish I share the same concern and anxiety as you have. It's literally in the hands of parliamentarians, is it not? So therefore, we have done our job. We don't have the conceit to believe that what we have done, what we have prepared and handed over to the government will be immediately absorbed by the government and then notified tomorrow or ordinance issued tomorrow. It may not. It still has to go through a legislative process. It has to be vetted by the Ministry of Justice. They'll have to say there are the draftsmen who will pour over the document which you have prepared. But I can assure you that the document of what we prepared, it meant 10 hours consecutively on several days for more than a month, intense debates for every section and for every kind of formulation, whether we should have conciliation also there, or does mediation take over conciliation completely, or to what extent, what will be the grounds of challenge at all. So therefore, these should we expand what Singapore has said. There have been issues like that. There have been very contentious issues, and ultimately we have made a document which is an interesting one. So will it come immediately? I think the government shares that interest, because when so many countries have been locked down and we want to open our frontiers for fresh investments, more employment generation, and we require some systems in place which will take care of disputes and which can resolve those disputes easily. And amongst others, there is nothing like mediation which can work. And with Singapore Convention to back that up for inter-country disputes where settlements take place, where there is a cross-border element there, the government is looking to immediately something which can work. Courts are overburdened. We take too many things to courts, or what do not require the forensic skills of judge to decide. So now we get the correct focus here. Almost every type of a dispute, we have at all times a concern that judges don't understand, the lawyers do too many things, they're costly. While all that is there, that we empower the parties themselves to generate options and then secure through a mediator. I think the best thing to happen. I'm sure the government was very serious about it. That is the way they've made it. Are you going to do it within this day, or is it going to be within another week? So they kept on breathing down on our necks, and therefore I believe that they are very serious about it. It should happen soon.
Thank you, sir. With that, I would like to conclude today's session. Please allow me to thank all our wonderful panelists for being here and for such an enriching discussion that we had today. I think my biggest takeaway from today's discussion is going to be the empowerment that the convention is going to bring, and a new ray of hope for young mediators, including myself, and probably hope for the growth of the profession worldwide. With that, I'd also like to thank CADR for organizing this event, and thank you to all our viewers for joining us today. Have a good night.
Thank you, Bhavya, and thank you. I believe just Kannan wants to come in. Yes, I believe that's it. Thank you, Honorable Mrs. Kannan, Francis, Paul, Dr. Singh, and Bhavya for a thoroughly exciting session. We'd seen a teaser of this a few days ago in the text, and the level of discussion in this session was far excellent. I'm certain that the attendees would have benefited enormously from that. As a young practitioner who is going to enter the world of dispute resolution, I know I have benefited from it. We thank you all. To all our attendees, thank you for staying with us. Uh, we understand that we have attendees from across the world. In India, it is dinner time. Francis joins us from Singapore, where it's usually midday. Paul joins us early morning in US, whereas Dr. Sukhsimranjit joined us at 5 o'clock, 5 a.m. his time. So we're very thankful to all our panelists and to all our attendees for sticking with us. We encourage you to visit our blog and to visit our social media handles. A summary of this lecture, of this panel discussion, as well as various other collaterals, such as the recordings, will be available on our website, on social media handles, as well as on the handles of our media partners, Law Octopus and Transnational Dispute Management. And with that, I wish you all a good night, a good morning, or a good afternoon, depending on the part of the world you join us from. Thank you, everyone.